5 seconds to go. Start. Be that as it may, mere presence of certain makeup particles cannot be a conclusive proof of the fact that the deceased was residing in the said house, especially when another woman was admittedly residing there. Furthermore, if Neelam was indeed residing there, her other belongings such as clothes etc. ought to have been found in the house, and even if not so, the other residents of the same house could have come forward to depose in support of the said fact. Notably, certain clothes such as two saris, two blouses and two petticoats were recovered along with the dead body of the deceased. The prosecution version is that the accused persons had taken away the said clothes from the house of the deceased while abducting her. There is absolutely no explanation for the said conduct on the part of the accused persons. It is difficult to understand as to why the accused persons would take her clothes along while abducting her. On the contrary, this fact actually serves the case of the prosecution in proving that the deceased was actually residing at the house in Simaltala. The clothes appear to have been planted along with the dead body in order to support the fact of actual residence of the deceased at her father's house in Simaltala. In light of the material on record, it could be concluded that no material whatsoever could be found at the house of Jang Bahadur Singh to directly indicate that the deceased was residing there. The makeup articles were linked with the deceased on the basis of a completely unacceptable reasoning and without any corroborative material. The prosecution has failed to examine even one cohabitant to prove the said fact. Furthermore, no personal belongings of the deceased, such as clothes, footwear, utensils, etc., could be found in the entire house. Therefore, we are not inclined to believe that the deceased was actually residing in the house at Simaltala. In the same breath, we may also note that even for PW18, no material was found in the said house to indicate that he was in fact residing there. Apart from his own statement, no witness has come forward to depose that the informant was a resident of the said house. The prosecution has not spotted any room in the entire house wherein PW18 was residing, and thus his own presence at the place of occurrence is doubtful. The appellants have also raised certain objections with respect to the time of death. The discrepancy has been flagged in light of the post-mortem report based on the post-mortem conducted at around 5:30 pm on 31st August 1985, which indicates that death took place around 24 hours ago. It indicates that the time of death must have been around 5 pm on 30th August 1985, which is contrary to the evidence of PW18 that the incident took place around 10 pm on 30th August 1985. A post-mortem report is generally not considered as conclusive evidence of the facts mentioned in the report regarding the cause of death, time of death, etc. It could always be corroborated with other direct evidence on record, such as ocular evidence of the eyewitnesses. Stop.